Alors bonjour à toutes et tous et nous sommes avec Marie-Laure très heureuse de vous accueillir dans cette sixième séance du séminaire de l'Institut Convergence Migration où nous allons continuer à décortiquer le pacte sur la migration et l'asile. Vous le savez, nous avons, après des séances transversales, décidé d'analyser chacun des instruments l'un après l'autre. Donc après une séance sur le règlement filtrage, une autre sur le règlement sur la gestion de l'asile et de la migration, et puis la dernière séance qui était consacrée au règlement sur les procédures d'asile. Nous voici donc arrivés à l'analyse du règlement crise et force majeure, donc ce fameux règlement 2024-1359. C'est intéressant de le resituer dans un contexte général, puisque nous savons que l'Union européenne est depuis quelques années omnibulée par l'idée de se préparer aux crises, d'être résiliente, comme le vocabulaire officiel l'indique, et on voit se multiplier les instruments de crise. Et en matière migratoire, ça nous donne cet instrument que nous allons analyser aujourd'hui, un texte très procédural, presque bureaucratique, que va nous présenter Mariana Gkliati, que nous sommes très heureuses d'accueillir et que je vais laisser Marie-Laure nous présenter.
I'm going to switch to speak English now to welcome very kindly Mariana Gkliati, who accepted to intervene in this seminar to present the crisis and force majeure regulation. She is assistant professor at Tillburg University. She is specialized in migration law and asylum law, and she is also involved in the refugee law initiative. She is the convener of the working group on externalization, and we think she has a way of presenting the crisis and force majeure regulation that will enlighten us and make us understand all the interactions between this regulation and the regulations we presented here before. So now, Mariana, the floor is yours. You can expose your presentation.
Thank you very much. Thank you very much, Marie-Laure, Ségolène as well for the invitation, and all of you for being here, and also for making this exception and allowing me to speak in English. I regret not speaking French, not the least because one of my areas of focus is West Africa, and I conduct research in Mali and Niger. So things can become complicated when you don't speak French. But I'm very happy to be here and participate in this very important lecture series. And I'm looking forward also to seeing what all of you are working on and perhaps find some common ground during the discussion later on. And I would like to ask you to please don't restrict yourselves because of language. If you would like to ask a question, if you feel more comfortable asking it in French, please do so. And Ségolène and Marie-Laure could perhaps be so kind as to translate it for me. Today, as Ségolène said, I will discuss a very important instrument of the pact, the crisis and force majeure regulation. And in doing this, I will present more or less the context of 3 articles, 1 published, 2 in progress, in order to give you as broad of a picture as possible on this issue and the different research angles that can be used. I myself have a legal background, and my research spans forced migration, border studies, refugee and human rights law. But I do have a multidisciplinary approach, and I use critical theoretical insights from the social sciences and political sciences as basically the conceptual foundations and seek to implement them via applicable legal solutions. So I was very happy also to hear that this is also an interdisciplinary audience. So apart from the law, I will also discuss angles related to policy and philosophy. I will first sketch the societal context within this regulation, how it was born, and its recent, short, but turbulent legal history. I will discuss then the steps for the adoption, the negotiations the last couple of years, and I will present also the instrument in more detail and highlight the main concerns that have already been expressed. And finally, I will present these new research angles which focus on exceptionalism. Again, this is new research, so if you have suggestions, criticisms, I'm happy to receive them both. I will now share my screen to get us started. Just a second. Okay, I think you should be able to see it now.
That's
yeah, we can see it.
Great. So let's take a first very quick glimpse to the crisis and force majeure regulation, just to know what we're talking about. The new Asylum Migration Pact, so it consists of 10 new regulations and directives spanning 1,400 pages of exceptionally restrictive measures. That was, as you know, adopted quickly in fear of an even more restrictive parliament after the elections, which we did get. Unfortunately, the political compromise created an environment full of exceptions, undermining protection rules in international law and EU fundamental rights. And central in this new regulatory framework is the crisis and force majeure regulation. This regulation allows member states to deviate from specific EU asylum and migration laws in order to manage crisis situations. These include exceptional mass influxes or cases of instrumentalization. Now, this regulation acts as an additional legal tool to address the challenges posed by mass migration flows, by force majeure events such as pandemics, and the politically motivated manipulation of migrant movements, which is referred to as instrumentalization. It was adopted last March, and it shall apply in July 2026, so we have 2 years to get used to it. But how did we get here? In recent years, pushbacks have become a common tool in the border management strategies of several European states, including Greece, Poland, Croatia, Hungary, and Italy. These states conduct pushback operations either unilaterally, in coordination with third states, or non-state actors, including EU agencies. Now, the operations can take several forms, such as pushbacks at land borders, at sea borders, pushbacks involving non-state actors, as I said, or pushbacks by proxy, or as there have also been named, pullbacks. Now, these operations may also include so these pullbacks are conducted in cooperation with third states, where the third state acts then as proxy by returning individuals attempting to leave its territory before they manage to reach European destination. Now, as there is no universally agreed definition of pushbacks, we tend to follow the definition of the Special Rapporteur on the Human Rights of Migrants, who describes pushbacks as actions that results in migrants being forcibly sent back without an individual assessment of their human rights protection needs to the country or territory or to the sea from where they attempted to cross or crossed an international border. Now, this definition characterizes blanket practices that forcibly prevent access to a state's territory without exempting beneficiaries of international protection. Now, given this complex, mixed nature of migratory flows, which includes refugees and also others needing international protection, and the level of violence often involved in conducting such pushbacks, human rights risks are inevitable. And these human rights risks include, by definition, the prohibition of collective expulsions, which is a well-established principle of international law that guarantees individual access to a fair administrative and judicial review. And this principle applies to all third country nationals regardless of their legal status. And collective returns without assessment or protection needs can also violate the prohibition of refoulement, fundamental principle in human rights and refugee law. But violations of maritime law, including search and rescue, safe haven, place of safety, effective search and rescue services within the designated zone, search and rescue zones, can also be at risk, can also be violated, and relevant also violations can be the right, with respect to the right of the effective remedy, rights of the child, the right to asylum, inhuman degrading treatment. There is a whole bunch of rights that can be involved in relation to pushbacks. Now, pushbacks are regrettably becoming a common tool in the border management strategies of several European states. Instrumentalization is often linked with the hybrid threat arguments and has been used to justify pushbacks in national rhetoric and in national law as well. So such arguments have dominated debates in Greece, in Poland, but also in Spain, Lithuania, and Latvia, suggesting that the situation at the borders is unique and can only be addressed by implementing a maximum level of security. This is the narrative. Now, these arguments have gained significant traction across EU member states on the periphery and have also been echoed by EU institutions, by the Frontex's former executive director, Fabrice Leggeri, for example. This rhetoric has also further been amplified by other EU officials, for instance, during the March 2020 incident at the Turkish-Greek border, where Turkey opened its side of the border, allowing large numbers of people to cross simultaneously. The Greek government responded with much pushbacks, unlawful detention, excessive violence, including live ammunition. EU leaders then showed strong support for and also suspension of asylum applications. And at that incident, EU leaders showed strong support for the Greek government, with European Commission President Ursula von der Leyen thanking Greece for being the shield of Europe, and later describing instrumentalization of migrants by Belarus as a cruel form of hybrid threat, so adopting the narrative herself. Now, this rhetoric has only escalated, as seen in her annual State of the Union address, where she described the situation as a hybrid attack to destabilize Europe. So political arguments and are still increasingly being used to justify and legitimize pushback practices and other illegal practices as a necessary and unavoidable response to perceived threats to national security. Now, special circumstances are said to justify urgent, exceptional, and even unprecedented action. Now, these arguments combine...
Oui, ça va? Oui.
I think someone needs to be muted. So these arguments combined with strategies of denialism that reject...
Issu de... Donc, Romain Batti a répondu qu'il n'était pas disponible le 5 décembre.
Mariana, quelqu'un dans
Voilà,
l'assistance
donc
a oublié de couper son
il faudrait
micro.
en fait qu'on
Sophie,
voit avec Reine Mathilde
s'il vous plaît, pourriez-vous éteindre votre micro?
et Henri Brunet. Bah, moi, je pense qu'il faut contacter les deux parce que...
Sophie Fauvel, pourriez-vous éteindre votre micro?
Bah si, ils sont partis en Allemagne.
Attends, j'arrive pas à le couper.
Ségolène, pourrais-tu couper le micro de Merci beaucoup. Mariana, you can go on. So sorry for this interruption of your presentation. So sorry.
It happens with online. Don't worry. So, trying to find my thread. So these political arguments that are used to justify and legitimize these illegal practices, arguing that there are special circumstances that allow for even exceptional and unprecedented action. These arguments are combined with strategies of denialism that reject the facts that pushbacks are happening, for example, and claims that the legal framework is insufficiently clear and can allow discretion or confusion about the legal obligations. These arguments threaten to alter the landscape of EU border surveillance, creating basically a new normal of extreme border violence. Now, this dynamic quite quickly also infiltrated EU lawmaking. The European Commission played an active role in addressing member states' claims of hybrid attacks and the instrumentalization of migrants, including imposing sanctions on Belarus and facilitating the returns of migrants who crossed into Poland without an assessment of their protection needs, potentially leading to refoulement. Now, when the new pact was announced in December 2021, this rhetoric was incorporated into legislation, including a broad and vague definition of instrumentalization of migrants in the Schengen Borders Code and the introduction of an instrumentalization regulation. Now, this regulation has been criticized as the worst of a series of bad legislative proposals by Ekre, that is. The regulation aimed to set up an emergency procedure for migration and asylum management in case of instrumentalization of migrants by a third country. And the proposal was allowed a wide derogation from the protection standards of the Séance instruments, especially concerning the right to asylum and the prohibition of non-refoulement and collective expulsion. Now, that did not go forward. The Council of the Commission were particularly eager to expedite the adoption of the instrumentalization regulation, but the legislative train ran across substantial obstacles. Member states were divided over the proposal. The majority of political groups in the European Parliament were opposed to it. So they failed to get a compromise, secure a majority in the European Council's negotiation froze, and the hope was then that the instrumentalization regulation would fade away. This was the end of it. But it eventually found its way through the back door, and it was integrated into the crisis regulation. So the regulation addressing situations of crisis and force majeure. So we now see it as the crisis regulation. This is as I said, the regulation addressing situations of crisis and force majeure. The scope of the regulation, what this constitutes a crisis, is still open to interpretation. The definition is quite vague. It refers to the first type of crisis is mass arrival, so an exceptional situation of mass arrivals. I'm not going to repeat the definition. The second type is instrumentalization, so where the third country or hostile non-state actor, including non-state actor, encourages or facilitates the movement of third country nationals or stateless person in the external borders, to the external borders or to a member state with the aim of destabilizing the union or a member state. So the preamble clarifies that non-state actors involved in organized crime, particularly smuggling, should not be considered as engaging in instrumentalization of migrants unless they have a clear purpose of destabilizing the union or a member state. And similarly, the preamble specifies that humanitarian assistance should also be excluded unless there is the aim of destabilization. And I can also highlight here that the final text of the regulation represents a sort of an improvement in legal certainty compared to either to earlier drafts under negotiation, particularly the earlier proposal. In the earlier proposal, the imminent risk sufficed to qualify as a crisis situation. Now this has been removed. Imminent risk does no longer qualify to constitute a crisis situation. So the terms of the definition still remain quite broad, leads a lot of space for ambiguity, a lot of space for interpretation. And we also have force majeure, which means the abnormal and unforeseeable circumstances outside a member state's control. And the preamble mentions there pandemics and natural disasters as an example. Now, the special regimes are based on allowing member states to derogate from EU asylum law with a range of derogations that they can request when faced with these situations. So this is the key phrase, that they can request these exceptions. And here we come to the procedural safeguards. Now, the crisis regulation is composed from a large extent of procedural rules. Now, the first set of rules concerns the determination of a crisis. So basically the determination of the material scope of the regulation. When should the regulation apply? Now, the regulation foresees a three-step process to determine the existence of a crisis. For the crisis regulation to be triggered in an exceptional situation, the process begins with a member state requesting assistance from the Commission. Now, if a member state feels overwhelmed by a mass influx or there is a force majeure situation, like a natural disaster, as I said earlier, it must submit a request to the Commission to determine the existence of a crisis. Now, the request must include a description of a situation, measures that are requested, the justification for these measures, and any details for measures that have already been taken, because as you will see, preparedness for a member state is also a requirement. Now, next, under Article 3.1 of the crisis regulation, the Commission assesses whether a crisis does exist, and if so, identifies which measures should be applied from the measures that the regulation specifies. If the Commission declares a crisis, then the request goes to the Council, and the Council becomes involved. Within 2 weeks, it must either approve or reject the proposal, and through an implementing decision, the Council will determine which derogations will apply. And additionally, the member states may be advised to use expedited recognition procedures for certain nationalities, which is also part of the regulation. Now, let's look at the specific measures to be taken. Again, I have more information on the slides, which I can share later, but I will give you now a broad overview. Now, derogations.
Sorry,
First,
excuse me, Mariana. We are still at the first image of your PowerPoint. So I'm wondering if there is an issue with you moving from one page to another. Maybe you can
yes, there should be, because I've changed.
start again sharing your PowerPoint in order for us to see all your presentation, because I think it's full of wide information and in-depth elements. So we'll see. Let's see if it's possible for you to go on.
Now,
That is the first slide.
This is the first slide.
Okay.
Yes, we can
Okay.
see. Yeah.
Second. Now we can see the second one.
good.
Go ahead. Third. Okay.
Yeah. Okay.
Rising trend.
Yeah, that's new.
Okay. Now that's
Okay.
perfect.
Okay.
Now we have the
Great. Thank you.
definition.
Good. That's wonderful that you said that.
Okay. Thanks a lot, Mariana.
We were here. Thank you.
Okay, great. Thank you.
Thank you. So again, broad description of the different derogations and the different measures that can be used, but feel free to, I will share the slides afterwards so that you can see more detail. So first of all, we have derogations related to registration of asylum applications. These are quite important. Member states are allowed to delay the registration of asylum applications up to 4 weeks. So the Asylum Procedures Regulation says that registration should happen within 5 days. That's the normal period, 5 days from the point that someone expresses the intention to request asylum. But in crisis situations, member states are allowed to just pause derogations for a month, for 4 weeks. Applications from persons with special reception needs shall be prioritized, and likely well-founded applications may be prioritized. So member states can choose. Next, we have derogations from border procedures. So these were derogations from the Asylum Procedures Regulation. Now, from border procedures. Now, border procedures aim to facilitate a swift assessment of asylum applications at the external borders, determining whether they are unfounded or inadmissible, and enabling a rapid return of those with no right to stay, without, though, admitting them to the territory of a member state. That's the fiction of non-entry. So under the crisis regulation, member state facing a crisis can modify, or they can extend the operation of these border procedures in several ways. They can extend the border procedure duration up to 18 weeks. They can issue exceptions from mandatory border procedures, and they can prolong the detention and processing. That's also very important for human rights risks, again, up to 18 weeks. and instrumentalization situations, member states can be granted discretion to apply border procedures, including then the fiction of non-entry and widespread detention and the restriction of procedural rights to all asylum applicants, regardless of nationality. So not just the nationalities that are not often recognized, but all nationals, with the exceptions of minors and individuals with special procedural and reception needs. Then there can be exceptions with respect to residence requirements and safeguards, and the timeline, that's not an exception, the timeline is also specified here. So basically member states have a 12-week deadline to decide on asylum applications from the time they're registered. Now, then we come to exceptions of deadlines and derogations related to the Dublin procedures. So it introduces significant flexibility within the Dublin framework in order to address these crisis situations. These adjustments extend procedural deadlines and allow for temporary suspension of certain obligations to support the member states under strain. And that means that deadlines can be extended. For example, the timeframes for submitting a take charge request from let's say Greece to from let's say Germany to Greece to take charge of the application is extended to 4 months. We also have suspension of Dublin transfers. Member states overwhelmed by an exceptional migratory situation may temporarily suspend Dublin transfers to their territory. Germany can say, the Netherlands can say no more Dublin transfers, or Italy in this case, actually. Until they no longer face crisis, and exceptions may apply. And relief for take-back obligations is also part of the deal for extraordinary scale that risks serious deficiencies in the treatment of asylum applicants. Now, this is an attempt to ensure that responsibilities for asylum claims are distributed fairly while still maintaining a functioning asylum system. That's the justification of these exceptions. Now these were the derogations. We come now to another area of measures that are responsibility sharing and solidarity measures. So there are also solidarity measures in the regulation adopted alongside the Council decision to recognize a crisis and force majeure regulation. Now, there are several types of solidarity and support measures that member states can ask for. First of all, relocation includes the relocation of applicants for international protection from the affected member states, financial contributions, of course, and alternative solidarity measures, tailored measures for specifically addressing the unique aspects of a certain crisis. Now, member states that take the responsibility above their fair share by examining additional asylum applications through relocation are entitled to a proportional reduction of their obligations under these solidarity pledges. This is another type of responsibility sharing and solidarity adjustment. And there are measures regarding implementation and monitoring with the EU Solidarity Coordinator. Now, the solidarity measures under this regulation largely build on the system established in the MMR, the Asylum Migration Management Regulation. However, the measures available during a crisis situation are broader, and they include additional options like the annual solidarity pool and requesting adjustment to solidarity contributions, subject, of course, to the decision of the Commission and of the Council. This is the flexible but mandatory solidarity regime that we have seen in other instruments. And finally, the third category of measures are the expedited asylum procedures. This is for groups of applicants from specific countries or regions where their claims are likely to be well-founded. So this measure is intended to streamline asylum processes during crisis and is guided by the recommendation by the Commission. Now, the key features of these expedited procedures, I have them here on the slide as well. Exception from personal interviews, no personal interview required to move things faster. Prioritization of applications, of these applications within the asylum system for swift processing, and shortened examination timeframe. Applicants who are, this is important, applicants who are identified as posing a threat to national security, they can be excluded from the expedited procedure. And again, without a judicial ruling that they represent such a threat. Now, I mentioned earlier crisis preparedness. This is also important. Member state must develop national strategies that include preventive measures in order to ensure their preparedness for cases of crisis and reduce the risk that they get in such a situation of crisis. For example, in the Netherlands, we were talking about, we have been for the last couple of years about a crisis in reception, but that's simply because not enough reception facilities are available. There are basically not enough beds made available, and the preparedness measures will ensure that in order to be able to ask for exceptions, you need to have taken all the necessary measures to prepare and assess also actions needed to respond to such situations, taking into account also the fundamental rights and the rights of refugees. Now, the analysis, policy analysts, NGOs have already been warning about the risks entailed in the instrumentalization regulation, even before it was the crisis regulation was adopted, on this regime of derogations. Now we also have the first academic critical analysis of this instrument, but there's still a lot of way to go to analyze this very important and complex instrument. And first of all, there are these human rights risks, and I tried to make a word cloud with the help of ChatGPT here. Now, the opposition of the instrumentalization regulation was fierce and came from various fronts in a rare alignment. UNHCR, the IOM, so that's the International Organization for Migration, and ECRE, they took a strong and explicit stance against the regulation. The European Economic and Social Committee also criticized the regulation. Its rejection was viewed original rejection was viewed as an advocacy success. There was a joint statement of 22 European NGOs expressing that their derogations are substantial, substantive, significantly affecting the rights of people. We have legal experts warning that this could become a tool for member states to circumvent their obligations under refugee, EU asylum, and international human rights law. It provides extensive and disproportionate room for derogations while lacking adequate legal safeguards for asylum seekers, thus undermining the already existing protection regime. I will not go through all the human rights risks because they are numerous. Perhaps I can highlight that delaying registration claims by extending these registration deadlines and prolonging the asylum border procedure to its maximum duration poses significant risks to procedural and reception rights and may lead to prolonged de facto detention. And combined with the border procedures measures, this de facto detention can become the norm. Now, we see also commentators, for example, Alberto Horst Neidart has seen that particularly in light of expanded border procedures, the regulation reaffirms that existing rules and guarantees, such as those in the Asylum Procedures Directive, remain applicable. However, he expresses concerns that the lack of automatic suspensive effect for appeals against negative decisions in border procedures could adversely affect individuals in emergency situations. So we have also these lack of procedural guarantees for effective legal protection. There are, again, several risks that for human rights because of the derogations. They're really so numerous. I do not have time right now to get into them. But there have also been analysis regarding the effectiveness, so policy approaches, the effectiveness and securitization expressed in this regulation. Now, the proposed regulation has received widespread criticisms for being ineffective in addressing attempts by third countries to coerce the EU and its member states, while also neglecting the structural factors that contribute to the use of such coercive diplomatic tools, as well as the EU's own role in this situation. So critics argue that it could also reinforce third countries' claims that the EU of the EU's hypocrisy and double standards on refugee and human rights. I can note the analysis of Melte Minnelli-Siquer, who has zoomed in on the force majeure exception in this regulation and has examined it has examined the regulation as compared to the Temporary Protection Directive, and sees that the European Union has been seeking a new legal instrument to manage the arrival of mass influx. And she reminds that the Temporary Protection Directive, prioritizing protection in situations of mass influx, has applied to over 4 million Ukrainian refugees with great success. Now, the approach of the crisis regulation is different. It's rather crisis management through broad derogation options. And that is exactly the opposite of what has been successful until now. Now, other commentators have looked at the potential effectiveness of the new system, examining basically whether the EU will be better off prepared for future crises with this regulation, with this common framework, with these exceptions, rather than having a common framework. And they note that the risks for legal certainty that come from this flexibility, these ambiguities, including in the definitions of the crisis itself and the other gray areas in the regulation. Now, my approach, which is in line with the aforementioned findings of ineffectiveness, has been that the crisis regulation is yet another manifestation of securitization. And I already showed earlier how instrumentalization has been used as a justification for pushbacks in national rhetoric and in law, and how it eventually found its way into the language of the Commission, into the pact, this language of hybrid threats. I published this article featured here last year, where I showed that the Commission has presented this regulation as a bright new and necessary way of addressing unprecedented contemporary threats. Now, the political and legislative attention devoted to the phenomenon of instrumentalization is rather yet another example of the multi-crisis analytical framework. And it's highly questionable whether the response constitutes a paradigm shift at all, actually. Now, the measures included in the instrumentalization regulation were already introduced after the refugee crisis of 2015 with the hotspot approach in Italy and Greece. And they largely resembled the border procedure proposed already in the new migration pact. Now, in fact, the Commission has continued an already existing trend. This is nothing new, in other words. So the instrumentalization regulation and now the crisis regulation reflects rather the natural continuation and the intensification of the securitization trend that has characterized the EU migration policy in the last 4 decades. Instrumentalization is the evolution of securitization, according to which exceptional and extraordinary situations, which are described as crisis, require new security measures. Now, migration is one of the primary issues that is seen as a security threat in the EU, thus justifying these emergency measures that would otherwise have been unacceptable. And while securitization has resulted in the related trend of migration and instrumentalization, does not only see a criminal or even a terrorist threat, but even more, a threat to the territorial integrity and the political stability of member states, and also the EU as a whole. So while migration narrative deploys the language of criminal law, instrumentalization goes one step further and deploys the language of the law of war to justify even more extreme responses to an even more acute existential threat. Now, to the new angles, I come to the research, which is still in progress, and I would like to focus here on the nature of the exceptions itself. So on the essentialist element of being a derogation from the rule. And by essentialist, of course, I mean the philosophy of essentialism starting from Aristotle, arguing that every object has a substance, or in other words, essential properties that define its true nature. Now, following the guidance of the essentialist philosophy, I study the exception, not the particular exceptions and their human rights consequences, but the essence of the exception. I consider exception, so the derogation, as the inherent unchanging essence of this regulation. It defines its identity, and due to its broad coverage, it also defines to a greater extent the identity of the pact as a whole. Now, I see exception as the intrinsic property, the essential nature of the crisis and force majeure rules. So in other words, there is no crisis regulation without the exceptions. The exceptions are the crisis regulation. There is no crisis management. There is no management of mass influx of instrumentalization without these exceptions under this framework. Now, this is the EU's new approach for dealing with such crisis. Let's examine the exceptions. Exceptions are, of course, not unknown to EU law. The lawyers among us will be able to follow this very, very quickly. Exceptions are designed to balance the uniform application of EU law with the diverse needs, the interests, and the sovereignty of the member states. So basically, they represent this eternal struggle between intergovernmentalism and supranationalism. The interest of the Union on the one hand, the interest of the member states on the other. Now, they play a critical role in ensuring flexibility while maintaining the overarching framework of EU migration and integration and compliance. Now, we have several legal bases for exceptions of EU law. In EU law, exceptions are found in treaties, they're found in secondary law, and they're found in the jurisprudence of the Court of Justice. Now, most notably, if we look at the treaty exceptions, we should note Article 72 of the TFEU, which allows EU member states to maintain public order and safeguard internal security, even when doing so may conflict with EU law. And we have some other more specific exceptions, such as Article 36 TFEU, permitting exceptions to free movement of goods for reasons of public morality, public policy, and public security. So when we look at secondary law, we found several instruments that contain exceptions that member states can invoke. For example, reception conditions directive contains provisions for derogating from standards of reception in situations of large-scale arrivals. Schengen Borders Code allows temporary reintroduction of internal border controls in exceptional circumstances, of course, and there are other exceptions that are set out in the case law of the court and are not found in the instruments, most prominently the rule of reason doctrine that the court established in Cagis de Dijon, again related to free movement, additional exceptions to free movement of goods known as mandatory requirements. So this is the general picture. Now, how has the court interpreted these rules? Whenever the court considers a justification that affects fundamental rights, it notes that these should not be, or they should be interpreted within the broader context of the Charter. In this context, fundamental principles such as the prohibition of torture and of refoulement are considered non-derogable. There cannot be any exceptions to them. And any exceptions to other rights are rigorously scrutinized to maintain adherence to international law and the Charter. Proportionality is another very important safeguard that the court puts here. No matter the measure, should always be checked against the principle of proportionality with this three-step test. Is the measure suitable? Is the measure the absolutely necessary? Is it the least restrictive measure possible? And still, is it strictly proportional? It should not disproportionately restrict the individual's rights. The last requirement that the court adds here to accept justifications is non-discrimination. Derogations must not result in discrimination based on nationality or other prohibited grounds under EU law. Now, this is the general framework for justifications. How about specific ones related to crisis and force majeure? Well, the court has already accepted in its case law the justification of force majeure in an emergency situation. Now we find prominent cases in customs and tax law, in public procurement, in environmental law, but we also have it in migration asylum law. The court has directly ruled on force majeure in such cases, not in migration asylum. There it hasn't ruled directly on it, but it has touched upon it. We have the Jafari case that I mentioned here. There, the court considered whether the extraordinary influx of asylum seekers constituted a situation that could allow member states to deviate from the Dublin regulation. However, it did not directly accept, in that case, the force majeure as a justification of non-compliance, but it acknowledged the possibility. Now, the court applies strict criteria for accepting force majeure. First of all, the event must be unforeseeable. The event must be external and beyond the control of the obliged party. And third, the event must make compliance impossible, not just difficult. Now, the idea is indeed that some flexibility should be allowed during emergencies to avoid disproportionate outcomes that could result from the rigid application of the rules. Now, the court has also evaluated derogations from the right to asylum and to family reunification for reasons more generally of public interest in the context of emergency measures. And in all the cases, the court applies the key principles discussed in the previous slide: proportionality, non-discrimination, non-derogable rights. Now, the first thing I can note here, which may seem contradictory to the critical tone of the presentation so far, is that there is a procedural improvement. There are procedural rules, there are checks and balances so that states cannot resort to the derogations on their own. Now, these measures cannot be taken autonomously, but they may be adopted by the Council upon a proposal of the Commission and after consulting the European Parliament. Now, in this respect, Iris Golder-Long suggests that this is a welcome development as it establishes procedural framework to prevent unilateral national measures, ensuring adherence to the principle of proportionality and the right to seek asylum. And it also provides member states with a legitimate mechanism to address situations of instrumentalization rather than resorting to pushbacks. Now, as in other areas of studies, she notes the European Commission can serve as the guardian of the treaties and when there are breaches, start infringement procedures. This is the safeguard she notes. However, the other side of the same coin is that, and here I come to my own analysis, that by attempting to regulate and add safeguards to what has already been happening in practice, see pushbacks, see suspension of asylum applications, the Commission essentially normalizes, it legitimizes approaches which were previously legally frowned upon. Now, this results in the deterioration of fundamental rights safeguards and adds to the rule of law crisis that has already been evolving at the external borders. Now, when the European Commission, in its attempt to protect the right to asylum, normalizes derogations from it, it becomes essential to reflect upon what really drives lawmaking. A second point I would like to make here. If we look at our discussion on exceptions on EU law, we see that we already had a system of exceptions, including ones on emergency situations. This was already possible. It was already there. The fact that a system for justification was already there shows that there was actually no good reason, no convincing legal reason for a crisis regulation. Third, we notice that whenever exceptions are provided in EU law, these are found in the same instrument as the rule which they modify, and they follow the rule. They come right after the rule. And there is a good reason for that. Derogations from the rule should really be the exception to the rule, should be exceptional for the rule of law to be safeguarded, and they are thus subordinate to the main rule. They come after the main rule. Adopting, in this case, a new separate instrument that allows for a broad range of derogations gives it a prominent place in the legal framework and puts it in a symbolically higher position compared to other derogations in EU law. And in this way, in this symbolic way, it encourages its use. It gives permission for the member states to use the justification more liberally. A fourth observation I can make at this point is that this, of course, is not enough to condemn the crisis regulation altogether. There are observations that need to be kept in mind during its implementation, but much depends on that implementation. The Court of Justice has clarified that Article 72, the article that provides for the general exceptions, general justifications for public order and public security, does not grant member states carte blanche to derogate from EU obligations. We also saw that the court always applies the tests of non-discrimination, proportionality, non-derogability of certain rights to accept a justification, to assess whether it will accept a justification. And it already has specific requirements, force majeure specifically. Now, the Commission and the Council should also test all these criteria when approving derogations. And it should also abide by the prevailing understanding that derogations should be indeed exceptional and resorting to them should be objectively justified. Again, much depends on how it will be implemented. Now, a prediction, if we are allowed a prediction on how the Commission will implement it, recent history patterns indicate that the European Commission tends to side with member states facing instrumentalization, often offering strong political backing and expressing, as we saw, the gratitude for their efforts. Now, this approach has generally included also refraining from initiating infringement proceedings against such states. Moving on to digging a little deeper, and I have here some notes for analysis, which perhaps we can dig deeper into during the discussion as well. First, the derogations included in the crisis regulation, the concept of crisis, the concept of instrumentalization are presented as an objective, phenomenologically neutral concept. But Konskaniemi, in the Politics of International Law, reminds us that international law, and yes, EU law is international law, is shaped by various power dynamics and political interests. And he invites us to explore the structural bias of seemingly objective rules. Now, The quick review I gave you on the background of the regulation allows us to understand the structural bias included in the concept of, in these concepts, as basically securitization. And here I will use again the words of Marty Koskaniemi, who explains that any concept receives independence, it becomes an autonomous carrier of bias, he says. So also the autonomous concepts of crisis and instrumentalization carry inherent biases that reflect the interests, the values, the perspectives of those who created and those who popularized them. Now, these biases shape how the concepts are understood, are interpreted, and are implemented. Now, what is now relevant is the implementation of the regulation, and we will have to see how that will go. But still, we need to take into account these the structural bias of these autonomous concepts. And now we'll come back to Koskaniemi, who shows that patterns in international law include that novel preferences, I quote, are consolidated. So the argument is that new developments require a new regime, which responds to the new challenges, not by replacing the old rule, but merely by creating an exception to it. And sometimes the exception may gain more ground until it becomes the new rule. This is what we know from Koskaniemi from his analysis of the patterns of international law. And we are now at this critical juncture. It will all depend on how these exceptions will be applied in the first couple of years. And we will then see in what form these new preferences will be consolidated. Now, the interpretation and implementation of the concepts of instrumentalization, of crisis, force majeure, need to be carried out in accordance with fundamental rights, with refugee law, including, of course, the principles of proportionality and non-discrimination. Now, the use of derogations and special regimes should be restricted to genuinely exceptional circumstances. However, of course, the current political climate in the right-wing swing in many European parliaments, in the European Parliament as well, it gives strong indications that misuse of this exceptional regime and continuous alleged emergencies are indeed a real risk. And this can mean the creation of a new normal of extreme border violence, which will have legal implications that can substantially reshape the EU area of freedom, security, and justice. And this leads us to a discussion on whether this can be viewed as a legitimate state of exception, as a fundamental aspect of sovereignty, according to Carl Schmitt, or whether we are being guided towards a new model of migration governance, namely what Giorgio Agamben calls a permanent state of exception. And I may offer here first attempt of an analysis. I don't want to take much time so that we can have a discussion afterwards. Investigating the nature of a new regime put in place by the crisis regulation, we can turn first to Carl Schmitt, prominent German legal philosopher, political theorist, who bore the concept of the state of exception. Now, Schmitt understands the exception as a fundamental aspect of the authority of the sovereign. Sovereign is he who decides on the exception. In other words, the sovereign has the power to declare a state of exception and suspend the legal order. Now, the state of exception is a situation where the normal legal order is suspended due to an emergency or crisis. It is an extraordinary situation that cannot be managed by the ordinary legal framework. During such times, the sovereign can take actions that are outside the bounds of the law in order to restore order and stability. Now, Schmitt argues that the law is not effective in dealing with extreme situations of crisis, and normal functioning of the legal order presupposes stability and predictability. Without it, so in times of crisis, we cannot have a functioning legal order. Therefore, in In the face of chaos, in the face of crisis, the sovereign must have the flexibility to act decisively beyond the constraints of the legal norms. Now, Schmidt's theory emphasizes the importance of decision-making in politics instead of the stability, the predictable framework of the law. And he believes that the essence of sovereignty lies in the ability to make decisive actions during times of crisis. Now, the decision on the exception reflects the true nature of political authority, and it demonstrates the power to determine the boundaries of the legal order. Schmidt finally criticizes liberal democracy for its emphasis on procedural norms and the rule of law, and he argues that such systems are ill-equipped to handle existential crisis. Now, he believes that liberalism's focus on the legal norms and individual rights, it undermines the ability of the sovereign to act effectively in exceptional situations. And his ideas have significant implications for constitutional theory, particularly regarding the relationship between law and power. And he challenges the notion that law can be entirely self-sufficient, and he highlights the need for sovereign authority capable of addressing situations that fall outside the scope of normal legal provisions. So Schmidt's concept, to close with Schmidt, of state of exception has been influential and also controversial, impacting debates on sovereignty, emergency powers, the limits of legal and political authority. His work remains a critical reference point for understanding the dynamics of power and law in times of crisis. I turn now to Agamben. Italian philosopher, he built on Carl Schmitt's concept of state of exception in his own work, expanding on it and heavily critiquing Schmitt. Agamben extends Schmitt's concept of the state of exception by exploring its implications for modern governance, for biopolitics, and the reduction of life to mere existence. He provides a critical framework for understanding how states use exceptional measures as a normal mode of operation, challenging the boundaries of law, of politics, of human rights. Now, Agamben argues that the state of exception has become a permanent paradigm of government rather than a temporary response to crisis. Modern states increasingly use the state of exception as a normal means of governance, blurring thus the lines between normality and emergency. And Agamben introduces here the concept of bare life, which you see also in this artwork here, vita nuda, and the figure of homo sacer. From Roman law, it is he who can be killed but not sacrificed. In the state of exception, individuals are reduced to bare life, stripped of political rights, and exposed to the arbitrary power of the sovereign. Now, the state of exception creates zones where the law is suspended and individuals are excluded from legal protections. And he sees the concentration camp as the most extreme manifestation of the state of exception. Now, the camp where law is suspended and bare life is exposed to sovereign violence becomes thus the hidden foundation of modern political power. It represents the spatialization of the state of exception. Now, Agamben highlights the threshold or the zone of distinction between law and violence, legal norm and life, and the state of exception. In this zone, the legal norms are suspended, but their suspension itself becomes a form of law, as we have seen very clearly in the crisis regulation. Now, the state of exception is characterized by this ambiguity and the merging of judicial and factual orders. Agamben builds on Foucault's concept of biopolitics, where the focus of political power is on managing life. In the state of exception, sovereign power targets life itself, making decisions over who lives and who dies. And this biopolitical control is a key aspect of modern forms of sovereignty. Now, Agamben argues that contemporary states have institutionalized the state of exception, making it a permanent condition. And this leads to a continuous state of emergency where exceptional measures become routine and the distinction between normalcy and emergency is dissolved. And this is also the pattern we see with securitization. This analysis challenges traditional legal and political theories by revealing how the state of exception undermines the rule of law and democratic principles. Now, it questions the legitimacy of sovereign power that relies on the perpetual suspension of legal norms. Agamben advocates for the need to confront and resist the state of exception. And he suggests that recognizing and exposing the mechanisms of the state of exception can open possibilities for new forms of political and ethical life beyond sovereign violence. And here I close so we can have a good conversation afterwards. If the state of exception created, basically the question is the state of exception that is created in the crisis regulation a legitimate and a necessary aspect of authority of the sovereign, as Schmidt wants us to think of it? Or does the EU risk the creation of a permanent state of exception, according to Agamben? Basically, the structural bias, again, come back to Konskaniemi, of the concept of instrumentalization and crisis suggests that this is simply the development of the notion of securitization, but on steroids. So the risk of Agamben's fears is present, but concepts in international law become autonomous, get their own life. So we will need to see what life these concepts will eventually take. Again, it will depend on implementation. And as I mentioned, the regulation brings upon an important procedural improvement, the procedural rules, the checks, the balances, so that states cannot resort to the derogations on their own. So it will depend on the implementation by the EU institutions and on how liberal they will be with accepting reservations, with accepting the justifications, or whether they will indeed uphold the spirit of the derogations regimes as it is now, until now in EU law, which suggests that derogations must be truly exceptional in nature, they should be secondary to the main rule, and they should be strictly interpreted when it comes to measures affecting fundamental values of EU law, and with the application of the tests of proportionality and non-discrimination. And it is of paramount importance that these tests established by the Court of Justice are already applied by the Commission, by the Council when examining the derogation request. And only this way can the rule of law really be safeguarded at the EU level much earlier than needing to resort to the legal protection offered by the Court of Justice, so at a much earlier stage. Thank you very much for your attention. I know I said a lot. I tried to have something here for everyone, a little bit of policy, a little bit of law, and a little bit of philosophy. And I'm very curious to see which angles you found interesting and you would like to comment on.
Thank you so much, Mariana.
Thank you.
Go ahead, Mariana.
Please, everyone, do not worry. You can ask questions either in French or in English, either writing down in the chat or getting up your hand and taking the floor with your camera on. It will be great to create a space of discussion between Mariana, you and us, and we welcome your intervention as soon as they come. But maybe to introduce the wave of discussion, I wanted to put some elements on the light. It could be possible to talk about Carl Schmitt and Giorgio Agamben. I wrote a lot about them. I'm very cautious, and maybe, Mariana, I can invite you to read all the papers that Elspeth Guild and Didier Pigot published in order to be very careful, be very cautious in the way of using their approach as, well, we have the contextualization of the thinking of Carl Schmitt for one hand, and we have the philosophy background of Agamben on the other hand, and maybe they are not possible to be introduced in law in a neutral value-based. So this is an observation. I have, in fact, two questions I want to highlight. I'm very happy Gavrans have a question, but I'm going to ask a question, and therefore I will give the floor to Gavrans that could put on a camera so we can see her face. It would be great. So the crisis and force majeure regulation, do you think, Mariana, that such a regulation will allow the EU member states to use pushbacks in a more important manner? Is it a tool that the member states created in order to legitimize, justify, organize the pushback practices they are developing since the 2014, in fact, and more since the 2020? This is the first question. The second question, you insisted in the importance of the implementation of the mechanisms of crisis, force majeure, and instrumentalization. And you highlighted that in the way the mechanisms are implemented, the necessity, the proportionality, the protection of the fundamental rights, in particular, the non-discrimination is anchored there. But I wanted to know what is the margin of discretion member states can have in such a mechanism. In other words, you insisted in the procedural improvement we can find about instrumentalization in the regulation. There, I'm quite suspicious because we have a proposal of the Commission. And for instance, the Ursula von der Leyen Commission is not going to confront with member states. We saw alliance where extreme rights. So we can imagine that the Commission will not be a barrier to human rights infringement. Afterwards, we have a consultation of the European Parliament. It's only a consultation, and we have a right, an extreme right parliament at the moment. So I think that derogation to human rights protection will not be a problem for the institution. And afterwards, we have the decision of the Council. I do not remember if I think it's a qualified majority decision, and I'm not sure. And here we have, I think, a majority of the member states, maybe not Spain at the moment, that would be favoring a derogation to human rights protection obligations. So is this really a procedural improvement? Is this a procedural guarantee of human rights of migrants in the crisis and force majeure regulation? That were my questions. Maybe, Garance, we can have the answer of Mariana to these two questions, and after you will have the floor.
Excellent. Thank you, Marie-Laure, for kicking this off, and excellent observations. Absolutely, I'm aware of the risks for using indeed Agamben in this framework, especially Schmitt. They have been so the critiques have been included in the paper, but now it's too soon it's too little time to get into that. But thank you for pointing it out. I could not agree more with your concerns. So indeed, it can be, this is precisely the fear, that this can become a justification for pushbacks. Not just pushbacks, a justification for extremely long detention, detention becoming the rule, suspension of procedural safeguards becoming the rule, suspensive effective appeals, for example, the fiction of non-entry and all that, but also specifically pushbacks as well. Maybe they can be happening in a less forceful way. At least maybe they will not be shooting them at the borders. But what we have seen already, so the example that we saw already before the adoption of the regulation was that of Belarus. So first of all, Greece, where the Commission just accepted and congratulated Greece for its approach in 2020, but then also with respect to Belarus, the Commission, so first of all, imposed sanctions on Belarus, but also facilitated the return of migrants who had crossed into Poland. So basically the commissioner, the commission president herself facilitated people who had managed to cross from Belarus to Poland to go back to Belarus without assessment or their countries of origin, without assessment of their protection needs. This is collective expulsion, possible refoulement, possible violation of the rights to asylum, depending on who was in that group. This was never assessed. The Commission already did this. So now with the regulation, it has even more justification to do that. And indeed, implementation is important, and we should keep I don't know. I don't even want to say we should keep an open mind, because you're absolutely right. So the current is against us. So the Commission has proved itself. The current Commission has proved itself. The Council the majority of the Council is right wing, and the majority of the Parliament as well. So its implementation will depend on that. So again, last resort remains the Court of Justice. But we shouldn't wait for the Court of Justice to speak. The Court of Justice has spoken, has set the rules, the borders, with the framework within which these exceptions can be used. Even if we now have new regulations, still the principles still apply. So at least we can perhaps try to have hope on the rule of law and push our European Parliament, push our governments towards this and the policymakers towards this direction. But given the political dynamics, this remains a very dangerous instrument. And the fact that the application of the instrument and whether there will be serious risks to the rule of law and human rights depends on the implementation, and the current political climate in the institution is on its own a violation or a threat to the rule of law. So the ambiguity that this creates, the it depends nature of the conversation we are having, it depends on politics. The application of the law should not depend on politics. This is precisely what makes this a very dangerous instrument and not a good law, basically. And absolutely, I agree with your concerns.
Thank you, Mariana. We can give the floor to Garance. Garance, you can switch on your camera so we can see you. It would be great. And you can ask your question either in English or in French. And if you ask in French, Ségolène or I will translate in order to Mariana to understand and to answer it. The floor is yours. You are unmuted. You're muted. We can't hear you at the moment. Oh, okay. You are writing on the chat. You can't unmute you. Okay, so write down your questions.
It is unmuted now. You can try.
You can speak now. That's okay. We can't hear you.
No, okay. So perhaps on the chat then.
Yeah, on the chat it would be easier. Yeah.
Okay.
All the others, do not worry. You can ask questions either in French or in English.
Let's see.
Maybe waiting for the questions of Garance, I would have liked to understand the procedural safeguards existing in the crisis regulation. Are there inexistent at all regarding the crisis. I thought that the decision was a proposal of the Commission and afterwards a decision of the Council and afterwards states deciding to use the possibility of derogation of the measures at the borders, but I do not remember exactly this instrument. So if you can highlight more precisely the technicalities of the derogation of the different instruments of the pact with the crisis and force majeure regulation, it would be great. But now, do we have the questions of Garance? Not yet, not yet. But we have, Mariana, maybe you can answer my question about the technicalities. And afterwards, we will have the question of Garance. And afterwards, I will give the floor to Nermin, if that's okay for you.
Of course, of course. That's a very good question because that's something also that I needed. I was planning to dig deeper on. You're right. There is already some procedures in place with respect to using the justification of Article 72. 72 of the Treaty for the Functioning of the European Union. And this is something, a conversation we were having in 2020, basically when Greece suspended asylum applications, then they used the justification of Article 72. And the response was that states cannot just use 72 on their own. Article 72 also has several procedural safeguards in the article itself. I still need to get, and that requires, again, a permission from the Commission and the Council. But I still need to get into the exact comparison between the two. So I will get back to that.
Okay, thank you. We have a first question of Garance, and she's talking about the rapid procedure. I do not know if it's the accelerated procedure or the expedited procedure. So we have two very different cases because the accelerated procedure existed before, but his mandatory application was extended. And it was the expedited procedure. So you have the question about the expedited procedure. It is an instrument that is used in Greece. So the question is to know if it's a new element that we have in EU law. And the second question it is about the border procedure in case of instrumentalization and the possibility for all asylum seekers to see their asylum application examined in the border procedure when instrumentalization is considered. And Garance is quite puzzled by such a situation we can find in the pact. So Mariana, you can react to these two questions of Garance you can find in the chat.
Perfect. Yes, first of all, indeed, the expedited asylum procedures is not new. So what the crisis regulation does is introduces these procedures for groups of applicants, even if their applications would not have been considered a priori well-founded. So this measure already exists and is intended to streamline asylum processes during crisis. And now it becomes even broader, its application. So basically, the Commission, so that's the technical aspect, the Commission can recommend applying an expedited asylum procedure when there are objective circumstances that indicate that individuals from a particular country of origin have well-founded claims. And what happens with the crisis regulation is that there will be no personal interview required. Interviews may still be conducted. That depends on the member state, the discretion of the member state to ensure to ensure that the applicants do belong in that specific group. Applications can be given or are to be given priority to ensure this swift processing. And there is this shorter time frame. Also, the exclusion I mentioned earlier of those who are considered a threat to national security. Now, with respect to the second question, let me see. So the surprise is that asylum seekers would be excluded. Oh yeah, so that only children will be excluded, and other vulnerable groups, basically. If it would be technically possible, I wonder whether you could expand. I mean, yes, indeed, this is the rule. Whether it would be possible, how do you mean that? How would be technically difficult to do that? You mean that there will be too many people having to go through the border procedures? Yes, indeed. Yeah. I assume that this would need one of the solidarity measures as well. So in order to be able to implement that, perhaps the support of Frontex will be needed for screening and fingerprinting and processing, like we have seen in the hotspot approach, basically, and the asylum agency. So it is basically the broader application of the already existing approach in the hotspots in Greece and Italy. So yeah, until now, we have seen prioritization of vulnerable groups, but now it's indeed even broader. So indeed, for countries like Greece, like Italy, to be able to deal with the mere volume of the registration, of the processing, they would definitely need solidarity support from the EU institutions in this form, because I cannot imagine that financial contributions could do something here.
It was a question by Nermin, if I'm correct, right?
Yes, exactly. You've already, first of all, thank you so much for the presentation. I really thought it was really interesting how you went through like all this interdisciplinary like aspects to it, and I really like appreciate that because it always like is another perspective on it. Some of the questions that I had in mind, you've already answered to them, so I'm going to try to come up with two other things. The first one, which also I had in mind, was the fact of how also on the procedural safeguards, because when you look at the crisis regulation from a procedural side, it is already an advancement, and like comparatively to other ad hoc responses that we've seen over the years about what was interpreted as a crisis. The only like maybe, and this is where like I need your expertise, correct me if I'm wrong, the problem is like I feel like all the consequences of like member states overusing it or not complying with whatever like deviation they benefit of, they all come post-crisis, because within the crisis or like the activation of the crisis regulation, I feel like from what I know, or this is where I would also need your help with it, probably like all of these procedural safeguard, they safeguard the rights of the members to sort of like profit from this crisis regulation, but they do not necessarily like show how would an institution intervene within, for example, this 1 year of one derogation to say, okay, this is enough, it's not a crisis anymore, it's not instrumentalization anymore. So maybe like you can expand more of like these like procedural safeguards to stop when there is no crisis anymore, or there is like, you know, sort of like a council or commission or other like entities from the EU saying it is not the case anymore. So maybe like I would like to hear your opinion on that. And I wanted to add one more thing about the zone of being or non-being. I also like, I'm a great fan of Agamben, so we can agree on that. And I was like thinking at the same time when I was also like reading through the crisis regulation, like looking at also like the temporary directive before that, and I was like thinking the whole time that also from like a post-colonial sort of like perspective, that this crisis regulation was made for like, you know, to manage unwanted migration. So basically you create the temporary directive was already like activated for Ukraine, but not other groups and so on. And I was thinking at the same time, like, I see like, you know, the disadvantages and advantages of like using this argument or like this framework, but I also think it's really, really interesting to do it, because also from my thought or like my reasoning says that this crisis regulation already enforces the infrastructure of like the zone of non-being or the zone of non-law, which I would think like this also really great perspective or like great thread for you also to like just like concentrate on, just because I also felt it was a permanent state of exception, and you can definitely like find a lot of other exceptions to sort of like fit within that narrative. Again, I'm happy to have been here. Thank you so much for your presentation.
Thank you, Nermeen. Very, very interesting comments. May I ask about your background as well?
I'm a PhD student in like University of Munich, and also just started like 1 year ago my PhD here, so I'm still fresh.
Excellent. And is it on law?
It's not on law, but like we work on synchronization and like migration, or like I work on like synchronization and process, which like basically we look at policy making from temporal perspective, and I look into migration stuff. But I still work on externalization. My PhD topic is not yet like finalized, and I also like I've written a research note on the crisis regulation, but it's not yet like anywhere. Like we're still like under R&R, so we'll see how far it gets.
Great, great. I'm curious. Just send me an email. Let's keep in touch about this.
We'll
So
do that. Thank you.
to get to the questions. Okay, so let's see the procedural safeguards. Yeah, basically the question is, when does the crisis? Okay, we will decide, the institutions will decide when the crisis starts, when the crisis exists, but when does the crisis stop, basically. So theoretically, you have the procedural safeguard that the measures are going to be they're going to be authorized for a specific period of time. And when it comes to the application, the suspension of asylum application, or the registration of asylum applications, for example, then the time limit is already in the regulation, up to 4 weeks. But for the other measures, the council and the commission, they can decide on the specific time frame. But so this could be part of the answer. The institution will decide how long the crisis lasts, but there is nothing in the regulation that prevents member states from asking for submitting a follow-up application, and then a follow-up application, and then a follow-up application, and then coming into the circle of perpetual crisis. And that we have seen this happening actually in the Schengen, in the internal borders, in the Schengen internal borders, with exception after exception after exception, and then you have basically closed borders in certain member states. So this is indeed a very real risk. Now, looking at the Temporary Protection Directive, yeah, we need to really remind ourselves that this regulation does not repel the Temporary Protection Directive. Temporary Protection Directive still holds. So now we have two regimes for dealing with crisis, and it's a matter of choice which one to use. And there is nothing in the crisis regulation that says that member states should justify why they don't use the Temporary Protection Directive. Basically, states cannot use the Temporary Protection Directive. The Commission needs to and the Council needs to activate it, but basically why they don't ask for the activation. So there is nothing that kind of prioritizes or takes the Temporary Protection Directive into account. It's just a decision of the Commission and the Council whether they will activate it, and then we can come into discussions of non-discrimination. Why will the Temporary Protection Directive be activated for certain groups with certain characteristics and not for others? But there is, again, no need to make that justification in order to use. And indeed, I found your observations about the non-being and the state of non-law very, very fitting in this situation, because either you have a choice between the protection framework of the Temporary Protection Directive or the exceptions and the not just the non-protection, but the non-law. So not protection from refugee standards, but also not from human rights standards. So I find that very, very interesting as well. I'm not sure, Ségolène.
Yeah, maybe just as a follow-up on the Temporary Protection Directive and the articulation between the crisis and force majeure regulation and the Temporary Protection Directive. I fully agree with you that it is not very clear who's going to decide and when and under which condition, which regime to activate. But still, when you're reading the crisis and force majeure regulation, you have more conditions, because when you're just reading Article 2, when a member state is writing the reasoned request to ask the Commission and later the Council to trigger the crisis and force majeure regulation, you have a number of justification to give. You have to justify that the system has become non-functional, or that you're facing abnormal and unforeseeable circumstances, etc., etc. All these kind of conditions that you do not have in the Temporary Protection Directive. So I think it would be much easier to activate the Temporary Protection Directive than the crisis and force majeure. So that was the first question. It's about are there legal criteria that incite us to think that there will be more chance that one system is activated rather than the other one. And my second question, we can continue, a lot of questions. By the way, thanks a lot for all your presentation. It was really, really interesting. My second question is still on the articulation between this text and the AMMR. And in particular, in the crisis and force majeure regulation, several times you've got a reference to the fact that the system that will be put in place by the Council will have to be articulated with the possibility not to use this regime, but to refer to what can be done under the regime of the toolbox that is organized by the AMMR. And to me, that is not very clear. Who's going to decide what? Do you understand something of the system, or do you really think it will be a matter for, okay, let's see what will happen and what the Council decide and what the member state will see? And my last question and remark, and I really appreciated the effort you made to try to make sense of the political and philosophical evolution of the law. I would agree with Marie-Laure that it's not always easy to apply a theoretical model to a system like the one we're observing now. But I will have one very naive question that is, do you really think we can use the approach by Carl Schmitt here? Because the main difficulty that I would face here to transpose this theory to the regime of exception that is currently built at the EU level is that who would be the sovereign? I fully agree that we can say, okay, the sovereign is the person finally deciding on the exception, but how can we identify a sovereign in a multi-level system? Who would be the sovereign? The EU and the Council and the Commission decided, or the member state? And as long as we will always have a combination of EU institutions and the member state deciding, can we have a sovereign here? So theoretically, for me, maybe that would be a difficulty to use and to borrow from Carl Schmitt's approach. But that's a very general question. Anyway, thanks a lot.
Very good. Marie-Laure, would you like to ask your questions now or after?
In fact, it was simple, following the remarks and observation of Nermin and the answer you gave to them. I was thinking of all the papers Sarah Ganti and Dimitri Koshanov published about the idea of lawlessness law. So a law that creates lawlessness. So I think maybe the crisis and force majeure regulation is a paradigmatic illustration of such lawlessness law. Maybe you can use it and exploit such idea, such a concept in order to manage the relation with philosophy and with political theory and with theory of law. So giving more emphasis on the transversal analysis of this regulation. That was my point only. But we have another question in the chat. So this is Mariana that is talking to you. You can read it.
Before we move on.
Oh, okay, yeah, sorry.
Is it okay to just respond to Ségolène, because I'm afraid with all the different...
Oh, yeah, sorry.
Thank you. And I will definitely delve into the literature of lawlessness law, because I haven't. So thank you very much for the suggestion. I will do that. This is a very interesting, very particularly lecture series. So I think I'm leaving with more questions than answers. It's great to take the research forward. So. Indeed, I agree with you, Ségolène. It's not clear who will decide on how it will be decided upon which framework to use. And theoretically, you could say that it is technically, legally more difficult to use the crisis regulation, but I'm afraid this will be the rule. In fact, the concern is that temporary protection directive will die. So it will only have been activated once and probably not again, even though it was a huge success. But looking at the possibilities for migratory movements and the characteristics, the identifying features of the people who will need or who will constitute the mass influx, it is fairly possible that we will not have the activation of temporary protection directive again. Even though theoretically, technically, legally, it would be easier to activate that than the crisis regulation. But again, this is the discussion of how the exceptions can become the norm. Now, with respect to the toolbox of the new Dublin, basically, we have so many different frameworks of flexible solidarity, mandatory but flexible solidarity, and the connections between them are really not clear. So the only thing I can say is that there is the procedural steps with the crisis regulation are different than with the MMR. So basically, the solidarity measures that are in the crisis regulation can be activated only with the procedural steps going through the commission, consultation of the parliament, and then decision of the council and implementing measures. The idea, without having done specific research into the travaux préparatoires, but my understanding of why these measures were also included in the crisis regulation is basically to kind of balance out the derogations so that member states cannot just ask for exceptions, but the commission and the council can come back with solidarity measures instead of exceptions or together with the exceptions. So this is a kind of attempt, in my understanding, of a balancing act. Otherwise, yeah, perhaps there would be no need to have that, since you have the solidarity measures in the MMR and in the borders, the screening procedures as well. So let me see if you have some other notes. Oh yes, who will be the sovereign? That's a good one. So, and that's something I'm just thinking on the spot. But it is indeed necessary to make the connections between the theoretical framework presented by the philosophers and how it applies here. So if I would need to make the link now with here, who the sovereign would be here, I would understand the sovereign as the combination of the two institutions with the consultation of the parliament. So the sovereign would be the commission and the council, with the council representing the interests of the member states. So we come to the balancing act between supranationality and intergovernmentalism within the EU and in this complex governance structure, which was not very relevant in the time of Schmidt. So in this case, I would definitely think that the sovereign is not the individual member state asking for the exceptions, asking for the measures, but the one who decides in this case would be the commission and the council. And then we have a special character of the sovereign, which already includes a balancing of several interests. And so we could never have the, given that the European Union is embedded in the rule of law and with all these procedures and safeguards, we can never have the full application of Schmidt's ideology, basically. But, and this is also what Agamben sees as a risk, but in this case, we already have mitigated that risk, or the EU already has mitigated that risk through the procedures, and through the fact that the sovereign is already a little bit more balanced than the sovereign of Schmidt. So these are definitely things that we need to take into account. And thank you for that, for that thought. And again, yeah, okay, the question in the chat.
Can you read it loudly so people that are not reading the chat can understand what you are talking about afterwards?
Of course. So this is from my namesake, Mariana Cabral da Silva. And she asks, since the European Convention of or Court of Human Rights has so many times ruled the legitimacy of pushbacks, how can the new pact migration asylum not address the issue of pushbacks? Does it facilitate, just to clarify on this, the court has, oh yes, it has ruled on the illegitimacy of pushbacks. Yes, indeed, has ruled on the pushbacks being illegal. How is that not addressed in the pact? Does it facilitate bilateral agreements between the EU member states with non-EU member states, like, for example, the newly established Italy-Albania agreement? And she, oh yes, she cannot open her camera because she's at work. And do I make the assumption correctly that you work at an organization in practice, so not an academic in the sense? So it would be nice to see if we have also representatives from practice who participate in this conversation. So indeed, the Court of Human Rights has come the last year and a half with many decisions on pushbacks at the land borders especially, but also lately, I forget the name of the judgment against Cyprus on pushbacks at sea. So yes, it has been very clear on the prohibitions. And indeed, it has been a very relevant discussion during the negotiations that the political direction of the whole pact is towards more restrictive measures while not protecting against the current threats, against pushbacks, against the loss of life at sea and the hesitation of member states to engage in search and rescue. We don't have these we don't have new rules on enforcement on this. You could say that we don't need substantive rules because we already have human rights rules in place, as it shows from their application by the European Court of Human Rights. So theoretically, you could say the substance is there, but still, the substance of exceptions was also there, and we have a new crisis regulation regulating it step by step to ensure its implementation and enforcement, and we don't have something like that for violations at the borders. And these violations, I mean, this instrument did not need to be on pushbacks itself, because again, pushbacks is not a legal term, but an enforcement framework, a stricter enforcement framework for obliging member states to comply with human rights. And an even more important conversation we need to have is with respect to the rules on search and rescue, because there we really need a stricter regime. We really need a solidarity regime and clear obligations for the EU and not just for the member states, because for the member states, we have the Frontex Sea Operations Regulation, which is called Frontex, but refers mainly to the member states. But we need clear obligations for the EU because the EU as an international organization does have obligations under the law of the sea, but they are not specified in the EU legal framework. And we have this very unclear regime on its obligations and then its subsequent responsibility when a disaster happens, and it happens all too often. So indeed, the political choices in the pact on where to focus on where to focus and where not are very, very clear and exemplified by your statement, Mariana.
Thank you. Are there any other questions or remarks? Or apparently no. But anyway, maybe it's time that we that we close the session. No more question, Marie-Laure? No. So I think we can really thank Mariana for this really fantastic presentation, presenting both the text and the background and trying to make sense of this political and philosophical evolution was really a challenge. So thank you for doing that. It's really helpful, and it helps a lot to have this reflection on the meaning of this exception system. Oh, Nermin, maybe you raised your hand? No, it was
No,
the
just clapping.
It was an
Okay.
applause, I think. Yes,
So I
a
think it's
well-deserved applause.
okay. So I think we can end the session. Thank everybody for participating. So the next, maybe I will shift to French for everybody. Alors la prochaine séance du séminaire est prévue le 5 février, toujours matin, et nous aurons la chance d'accueillir Paola García Andrade, qui est professeure à l'Université autonome de Madrid et qui est une des très bonnes spécialistes de la question de l'externalisation. Et elle nous parlera de l'externalisation dans le pacte sur la migration et l'asile, qui est une question importante, c'est récurrent, vous l'avez peut-être remarqué, dans beaucoup des instruments, de façon implicite ou explicite. Donc voilà, nous nous retrouverons à ce moment-là. Et merci encore d'être venu participer. Je vais arrêter l'enregistrement. Merci à tous. Au revoir.